laws, and maybe perhaps there is something that might be qualified as a disability, some mental issue that is creating the need to use alcohol or take drugs.
If someone has had that issue and the employer is likely to think there's going to be a problem here, I see it developing, and someone is under treatment, does that stopgap the employer from just unilaterally firing him because he's under treatment, which means I guess he can function at some level but not completely to the full extent of his perhaps initial responsibility or job title?
Well, I think it depends on the employer. If the employer has knowledge that somebody's under treatment and the employee takes a leave of absence, for instance, then it depends on the employer's policy. Maybe they can hold a job open for a period of time while the leave of absence is in place. If the leave of absence expires, the person doesn't come back, the employer may have the right to terminate employment. But then you have to go you have to look at other areas of employment. What if there's a what if there's a union, a private union? It's not as easy just to terminate someone because they have a right to grieve. Right. They have all these process.
There's a
it just depends on the employer.
As Jackie's saying, of rules
policy
that can apply to an employment situation. Is there a contract, private contract, an employment contract with you and the employer? That's an issue. Is there a union contract that might apply? That could be an issue. Does the company itself have a policy, an employee manual that you could look at to see what are their rules on certain things? Then you can get to the FMLA, the Family Medical Leave Act, or the ADA, or some of the other federal laws that might apply, or state laws that might apply. So again, you have to look at all of the factors that are governing your employment situation and apply to it, and then what are the particular facts of the situation that you're in.
What's a reasonable approach in terms of the process that you'd go through? Would it be go to see a supervisor first where you work, go to their HR department or their employee union, then a lawyer? What's the pecking order?
You mean for the employee?
For the employee.
What's
a reasonable process?
The direct supervisor. That would be the first place.
Right.
If there is a union involved, I would say your shop steward, your union leaders. If the direct supervisor is not giving you satisfactory answers, then I would say go towards higher management.
Right, and then the lawyer.
Yeah.
Let's talk about a special group, veterans. It's not surprising to hear that so many suffer post-traumatic stress disorder. In a case where a person had been employed by a company, took several terms of duty, came back. He might have been depressed beforehand, but he certainly has more problems right now. He ends up losing his family, and his job performance suffers greatly. Because he doesn't perform well, people chide him about his work. They write up his absences and his low performance. Next thing you know, he's fired. How does that play out?
Okay.
Should he be fired?
Well, there's, again...
There are always more issues than one. Go to it.
There's a lot of issues that are folded in there. First thing that struck me as you were going through the whole scenario is you're almost talking to me about a fellow who may have post-traumatic stress disorder from his time in combat. Certainly there are going to be VA benefits that are going to apply here and that need to be looked at. To go directly to your question, which was can he be fired for that, I don't have enough facts to find out exactly what he did at work or didn't do at work to tell me whether or not there's a legitimate ground for firing. Is he protected by the ADA against a firing? Well, the employer has to make some reasonable accommodations, but depending on what the facts are that you're telling me in this particular case, can a reasonable accommodation even be made if it's affecting not only his work but other people's work there?
Is the onus on the supervisor or the employer to accommodate that victim or that veteran who is obviously suffering from post-traumatic PT, thank you, is it the employer's responsibility to reallocate his job responsibilities?
That could be making a reasonable accommodation.
Yeah, again, the definition is a reasonable accommodation.
Reasonable accommodation is his impairment interfering with his ability to substantially perform any of the work duties. I think once the employer realized that there is a potential disability, I think the employer has an obligation to try and accommodate within a reasonable, within reason. If they can't accommodate because the work performance is interfering with his ability to do a job or interfering with other people to do their job, if they can't, in spite of an accommodation, then I think maybe the employer has more of a defense to terminate.
The employer, after having taken some reasonable steps, can get to a point
just do
where
so much.
it's just not going to work. Now, if they fire the person, I guess the question could be, is it a layoff or a firing? Is that for disqualifying reasons? Can the person collect unemployment? Can the person get VA benefits? Can the person get Social Security disability benefits? If it's work-related, is it a workers' comp case? Those are all things that need to be looked at. And the facts of each case are going to direct and determine where you go and what direction you might be allowed to get benefits from.
Let's go back to what you were saying for a second, Jackie, in the employer's responsibility. It seems like it would certainly be a reasonable, sensible, conscionable thing to do once the employer picks up on the fact that this veteran has just come back from his tour and he's struggling. Is the onus on the employer to make those accommodations, or only if the employee says, I have issues here? Because many veterans, when they return, they don't want anyone to know. They don't, as much as they can, they would like to keep that private because they don't want to suffer repercussions, which may be another issue. But where is the onus? Is it first on that employee to say, I have issues, yes, I may be in counseling, but please understand I have,
Something like
I'm entitled.
a mental impairment, I think, is much more difficult for an employer to diagnose.
Right.
Now you're putting them in a position where they have to be employer, doctor, sometimes even lawyer. Psychologist. Certainly if somebody is disabled, physically disabled, it's much more evident because you can see it. But a mental impairment is going to be much more difficult for an employer to identify. I would say in that case, maybe the employee needs to make some type of needs to have some type of conversation with the employer and tell them that he or she's going through this issue. Some employers do have programs where they'll refer you over to some, like the Providence Center.
Yeah, or some other counseling ability
Yeah.
unit that they have available to their employees.
okay, let's pursue that just for a second. Suppose the employer does suggest that, perhaps whether he is on the hook to underwrite it or not, it's another story. But suppose it's suggested, we'll even give you the time off to take to do the hour counseling a week or whatever. If the employee doesn't take that because he's in denial and he doesn't perform well, does that make it easier for then the employer to say, I'm sorry, we'll have to cease this relationship?
I don't think they can mandate that you go to whatever employee assistance program that they're seeking, that they're suggesting, but if the employee decides, I want to go to my own counselor.
Sure. They can't mandate who you treat with. It's an employee assistance program, as Jackie said, that's available
At
to you.
no cost, so the employer does pay for it if the employee takes advantage and goes.
If they have that program.
Yeah.
But they can't mandate that you go. Whether or not they can let you go or not let you go goes back to the work performance and...
And you're employee at will, regardless.
Right, exactly.
Even if you were in a union?
No, well, that's
Now,
a little
union
different.
different story.
contracts are
If you
always
read the
different.
paper,
Yes, that's a
not
subject
totally
for another day,
Yeah,
a subject for another day. But let's broach the subject about Social Security disability and workers' comp. Let's stay with this veteran for a moment. The job that he is to be doing, he's suffering, he's not working well, and he actually gets hurt
on the job.
on the job. His duties weren't changed, so now he could be on workers' comp, or could he be disabled? What's the difference, and how does that affect this kind of situation?
Sure. There's workers' comp benefits available to someone who is injured at work in the course of his employment and can't do the duties of his job. There are Social Security benefits available to someone who is disabled and can't do any reasonable job that he has the skill and training to do. Totally different programs, two totally different standards for getting benefits. So if this veteran got hurt at work
Yes.
and can't do his job from work, it doesn't matter what his disability going in was, because if he had a disability going in that did not affect his ability to do his job, and because of an on-the-site work injury now can't do it, he's the same as any other person who was able to do a job and now can't do the job that's hurt at work.
He's still entitled to benefits.
Entitled to benefits.
Yeah.
Let's go to another scenario that's not about employer-employee relations, but rather my basic right to vote. Here's a scenario, comment on it, if you will. A person comes to his polling booth to exercise his right to vote. The check-in clerk at the polling booth sees that this person is obviously not only physically challenged, but has some mental challenges or mental disabilities. That clerk says, "Are you sure you can vote?"
We got a problem.
Yeah, there's constitutional
Now,
rights.
what are the issues?
You're taking
And-
a fundamental right away from an individual who has absolute right to vote.
Right.
I mean, clerks can't demand that you show them a competency
No.
exam.
They can't give you a test.
They can't even ask for your license.
Right. There's some issues whether
Yeah.
at some point they can or can't, but the clerk is only there to look at the book, see if you are registered to vote, and if you're registered and you have the right to vote, they can't deny a ballot to you.
Now, what happens, I'll give you this what if the person that votes, the person wants to vote but tries to go into the booth and
Has difficulty.
They have
That's-
difficulty. I think you have a cause of action there because now you're preventing somebody from voting, fundamental right.
again,
And then
They can
They
make
have
some
a-
accommodations
they can make
to help
yeah, make
someone do that.
accommodations.
Remember when we had those machines that you had to close the curtain and
Yeah.
it had
Yes.
that big lever, and someone couldn't pull the lever? Well, they're entitled to have someone help them do that.
Mm-hmm.
That person can't stay in the booth with them if they don't want him in there,
Mm-hmm.
but they could help them close that lever so the curtain would close.
Of course, I'm sure there are many stories about someone saying, "I'll help you vote.
Right.
Let's just go right in that booth and we'll
that
close that."
doesn't happen, does it?
So what should that person do if someone is, never mind insensitive, actually acting illegally? What should someone do?
Oh, I think you have a cause of action.
Well,
Yeah.
you got a problem, though, because it's such a short window. There's other supervisors you have to appeal to right there on the scene, perhaps the board of canvassers or whoever's in charge of voting in the area. You have to act on that very quickly.
I think that if the towns and cities were smart, they would make the reasonable accommodations prior to voting. In other words,
Right.
they would say, you know, for every polling place, we have a designated area for someone who's, you know,
A wheelchair or whatever
can go
else
and vote. So
they need.
they would take preventative measures so
Right.
that they wouldn't encounter that problem.
Certainly, the physical disabilities seem to be more easily addressed, blind,
Yeah.
deaf, wheelchair-bound, but certainly with something that's a little trickier to deal with. Certainly, it makes sense that no one should ever say that, but if they had questions about, if that clerk had a question about whether or not that person was capable, what should he or she, as a responsible check-in clerk, do?
I don't think they can question someone about the
Yeah,
capability to,
No rights.
I would be
unless
very-
they know someone's under 18.
Yeah, well, you know, if
Okay.
they're not registered legally, that's a
Yeah.
different story.
Interesting. Obviously, there are so many different issues that are involved with disabilities. The good news is that for all that you can't do and take care of online, at least you have, we've found, Rhode Island and Massachusetts, and of course every state has its own website that caters to or has a section dedicated to disabilities. Obviously in Rhode Island it's www.ri.gov. The same is true of Mass. We hope that discussing some of these issues have been helpful to you. We always invite you to send in your questions to legalmatters@fullchanneltv.net. We hope that you'll stay tuned as we continue to discuss some of the legal matters, and that discussion will continue. We hope that you will join us. And I think in the next couple of weeks, we're going to be talking about some marital issues.
Maybe we could talk about domestic violence and the effects that has on families. We could also remind people of our email address.
Next time,
Next.
join us. Thank